Добрий день.
Good morning. Good morning.
Вітаємо вас, пані Людмила.
Welcome, Liudmyla.
Вітаємо вас на
Welcome
другому
at the
етапі
second
відбору
stage of the
Вищої
selection
кваліфікаційної комісії
to
суддів
the
на
High Qualification
співбесіди.
Commission of Judges of Ukraine at the interview stage. The interview is held by all members of the Selection Commission, to be more specific, by Robert Brugheisen, me, Ivan Mishchenko, Serhiy Verlanov, that's Zhechny, Stephen Markman, and Judge Yevhen Mezentsev has announced self-recusal due to your joint work in the Council of Judges of Ukraine. The rapporteurs are Robert Brugheisen and Serhiy Verlanov. So, Lyudmyla, before we start our interview, let me draw your attention to the fact that in case for some technical reasons the interview is interrupted, suppose there is no electricity or there is an air alarm, don't be concerned about that. The Commission will reach you and we will continue the interview starting with the point at which we stopped. The member of the Commission asking his question can actually limit your answer, and before the interview, you will have a chance to tell about your motivation, about your ideas, why you have decided to apply, and why the Selection Commission should actually recommend you. Thank you. Let's start our interview, and let me give the floor to my colleagues. Colleagues, you're welcome. Who starts? Robert or he?
Good morning, Ms. Volkova. I will be I'm your rapporteur on this case, which means that I have the honor to start questioning you. Before we start the interview, I would request you to shortly introduce yourself. Of course, we have read all the information. We know who you are, but we would appreciate for the viewers, others than us, that you explain who you are and what you do. And maybe you also can spend some words on your motivation to apply for this important position, the HQCJ. Please, not longer than 5 minutes.
Dear commissioners, I would like to briefly start with my professional background, which, as for me, will allow me to be an efficient member of the HQCJ in the conditions of crisis management. And let me draw your attention to the fact that I actually started with the state judicial administration, to be more specific, the territorial office, when this institution was under development and we were facing the task to change the approach to provision the courts for it to become a priority. And I'm sure that for the state services, among the state services, and I suppose we performed this task. Then I became the judge in the period when the load of administrative judges was probably the highest over the whole period of existence of courts in Ukraine, when people were standing in the queue from 5 o'clock in the morning. The elderly people, they were standing in a queue to just file their claims with courts. So I know how courts are working, how they are working under pressure in the field of administrative justice. I also worked in the Council of Judges in the period when a lot of judges were deprived of the opportunity to work in their territories because the territories were under occupation, and we had to settle those issues. And also, this period of my work in the Council of Judges coincided with the beginning of the judicial reform and qualification assessment. I also worked as a trainer in the National School of Judges. I developed some trainings, and this experience also allows me to understand how important it is to advance the qualifications of judges. Let me draw your attention to the fact that on the website of the Qualification Commission on the 13th of January, there were 2 figures on vacancies, and the most difficult is the situation in appellate courts. This is 58 vacancies. 2,000 people in general have not completed their qualification assessment, and it's important that 325 judges, as for now, don't have their mandate. I mean, that their work had to be redistributed among other judges who have their own high load. Why did I mention crisis management? I wanted to to draw your attention to the fact that the new High Qualifications Commission will start working during the war or right after the war in very special conditions when the families of judges are scattered, are dispersed not just only throughout Ukraine but throughout the world. And I know that a lot of judges are displaced persons. There are some courts where the archives have been left in the occupied territories, and this will all be the issues to be settled by the new composition of the High Qualifications Commission. So I think that this new HQCJ will have to work in special conditions, taking into account psychological condition of judges and taking into account all those sensitive issues. And I think that my professional background will allow me to be efficient and effective in such conditions.
Thank you very much for explanation. When I read the information about you, the first question that came up is that was related to the fact that you used to be a judge until 2018 and then decided to change your position and to become a professional lawyer. And you became a professional lawyer first with the law firm Kinsteller, which is a quite well-known law firm. And then, even I know it, can you imagine, and then to Avellum, which is also quite a well-known law firm. And now you decide to seek a position again in public office. Why is that so? Why did you leave the judiciary, and why do you want to go back to public office? I would say, but maybe I'm wrong, that a position within a larger law firm is much more comfortable than to be a member of the HQCJ.
So, answering the question why I have decided to try and become a member of the HQCJ is related to the fact that if you look at my professional background, I like challenges, and I would like actually to make my contribution, to use my professional achievements to make a contribution in the field of provision of the judiciary with proper staff. And I can work in the conditions of high load, and this even gives some additional energy to me if I have such situations. I like challenges.
Yeah, we all like challenges, but did you also like challenges when you quit being a judge and became a lawyer? Was that also the reason why you became a professional lawyer?
Yes, you're right. I changed the position of the judge for the attorney at law when in the international law firm, because when I worked as a judge, the financial provision of judges was not sufficient. And I didn't have a chance to maintain me and my family adequately. So when I was offered this position in the international law firm, of course, I was supposed to have higher salary. That's why I agreed, because back then it was really important for me to maintain my family.
Okay. In your position as a lawyer, professional lawyer, I don't know what you call this, solicitor, lawyer, attorney. Do you use the court system often for your clients?
I'm a court lawyer, and in those firms, in Kinsteller and Avellum, I used to work in the direction of dispute resolution, and I represent the interests of clients in courts.
Okay, because there, I believe, as a foreigner, quite some issues within the judiciary of Ukraine. Can you please, from your own experience, tell us how it goes if you go to court? Are you able to get a hearing quickly? Are you sure that you will get treated well? Are your clients certain that the judges will look at their case independently and honestly. Maybe a few views from your desk as a lawyer who is in litigation.
Well, first of all, let me draw your attention to the fact that high load of judges today leads to sometimes the long period of time for you have to wait for hearing. Clients don't always like this. Sometimes they have to spend the whole day in court to waiting because today is the day of the hearing, but the case is postponed till the later part of the day. Clients get nervous, of course, when they are staying near the courtroom. Concerning whether courts can really provide an honest decision, I always keep telling clients about this because I think that the Constitution of Ukraine, in the section Justice, Prosecutors, and it determines court, prosecutor's office, and the bar as all these three components of the judiciary, and the reputation of the judiciary and fairness of this decision always depends on these three components. So I always tell the clients that our decision will always be fair. If you don't like the decision, we can appeal in a higher court instance. This is important, as I think, because if the lawyer, the attorney at law, does not support the reputation of the court, there will be collapse in this system consisting of three components.
But that I find difficult because as an attorney to your client, you have the obligation to tell your client exactly what the position is and what he should do. And if your client seeks justice and it's not possible for him to obtain that, you should tell your client that and not protect only the interests of others.
I tell clients that we will then go to a higher legal institution and their interests will be protected since the decision is going to be fair. And if we get the final decision of the Supreme Court, it will definitely be a fair decision. And this all is the precondition of independent court. You know, if every party that loses the case considers that the decision is unfair, then we will never achieve any respect for court, including respect for prosecutors and attorneys at law. Respect for the court decision should always be there.
There are quite some, let's say, publications and information that there is corruption within the judiciary. Have you ever experienced corruption in the judiciary?
Personally, I have not been a witness of corruption in the judiciary.
And you are a well-known lawyer. No doubt you know the environment within the judiciary well because you have been a judge yourself. Have you ever felt that you'll be treated with more respect than your opponents when you go to a court and seek justice for your client?
No, I haven't had any cases like this when I felt this. Well, probably there were some situations when the case was considered by the judge, who was also a member of the Council of Judges, or we used to participate in some joint events, but the judge disclosed this information, informed the trial participants that he was acquainted with me, that we used to be members of the Council of Judges, but we don't have any friendship relationship. And he asked whether the parties would agree to consider to have the case considered. So I didn't get the feeling that the attitude to me was better than to my opponents.
Yes, well, we had one of our candidates who wrote in her letter that she once went to a court hearing and the judge said, dear lawyer, you can't believe that you will win on the law. It is much more important that you know the judges. Is that something that has any truth?
No, I would disagree with this. I don't know what the experience of this candidate actually was, but I would disagree with this statement.
Okay. Mr. Chairman, I would like to pass the floor to my co-rapporteur, please.
Of course, sure. Sergey, it's your turn.
Доброго дня, пані Людмила. Мене звати
Good morning, Lyudmyla. I'm Sergey Verlano. I'm the co-rapporteur
пані Людмила. У мене буде таке
in your interview, and here is my question.
безпосередньо ваше
We have studied your motivation letter,
бачення щодо
and we saw your vision concerning raising the level of trust in the judiciary. And you have indicated that suppose you are appointed a member of the HQCJ, the priority in your work will be improvement of the regulatory documents, effective completion of staff procedures launched by the previous composition of the Commission. You also focus on the timeline that no later than 2 months after the launching of the operation of the new selection, this will be for selection of judges, and you also indicate that there should be a timeline for submission of applications. Is it physically possible to actually do what you suggest within this timeline? What do you think, and why? Just in brief. I think that it is realistic, it is possible, because if we have the new composition of the HQCJ and we will have enough members, first of all, we will have to deal with selection of inspectors of this patronage service who were dismissed. But if we take pains, and by the way, I've indicated the statistics in appellate courts. I've already told this today. So we have to primarily work with this problem. All the more that we have the regulatory acts, the rules, and we can actually start working following those rules on the basis of the things which have currently been developed. But do you consider those timelines to be realistic? Yes, yes. As I have indicated it's still possible if we take pains, and we need to take pains. Of course, you need to use all your energy and persistence to manage this. Thank you, clear. And here is the next question, Lyudmyla. What do you think? What is the experience of your work that really will help you to assess judicial candidates and incumbent judges during the selection procedure? Well, first of all, that is all due to my general professional background and my knowledge, which I mentioned at the beginning of the interview. Also, my life experience and my work at the National School of Judges, where I prepared and delivered trainings, and where I conducted assessment of judges after those trainings in the form of questionnaires that include all the components, not just professional competence, but some other skills and abilities. So I think that if there is an opportunity like that, my professional experience will allow me to be efficient. Thank you. It's all clear about professional competence. And what about the criteria of integrity? What do you think? What should be the assessment of integrity like? What should be the criteria? Well, according to the legislation, we have to take into account the judicial dossier and the documents which have been received on the basis of the special inspection, as well as the documents coming from public organizations, civil society organizations, then that are in public access. This should all be done in integrity, assessed in integrity, following some values, following moral values.
Зрозуміло.
Clear?
Зрозуміло, пані Людмила. Дякую вам.
Thank you.
Наступне. Да, у мене все.
Steven.
Stephen?
Thank you very much for being with us today, Judge. Thank you for participating in the competition. I would like to ask you one question, if I might. I understand why, after 9 years on the judiciary, you might want to leave the court And I also understand why you might want to go to a respected law firm, as I understand you to have done. But I must please ask you what to me remains unclear. Was your departure from the court in any way related to a qualification assessment?
No. My transfer from the work in court to the lawyer's position was not related to qualification assessment because I had already been appointed as a judge for an indefinite period of time on the basis of the interview. But it so happened that this offer came from the international firm in February 2018. And there was no qualification assessment even appointed for me at that period of time.
Okay. There was no apprehensiveness of any qualification assessment that might be coming up in the future. Okay, thank you. I appreciate that. That's my only question now. Thank you.
Ted, please.
Yes. Ms. Volkova, I was particularly interested in your experience as a faculty member of the National School of Judges. And I wonder, can you tell us, please, if you had any involvement in that capacity with the preparation of the examinations or the practical case studies that candidates for the judiciary are, of course, required to complete as part of their applications for appointment. Did you mark any of those, and did you prepare any of those documents, and did you mark any of those products?
I participated in the development of the trainings since 2013 up to 2017. Over that period of time, I was involved in the development of trainings, in lecturing, in teaching, but I did not participate in the development of any materials for training of professional judges or professional judicial candidates. But during the trainings, I definitely marked and assessed the results of all the participants of the training.
There has been a suggestion, Ms. Volkova, that one of the things the High Qualification Commission could consider when it resumes its operation is shortening the period of time that judge applicants spend at the National School of Judges. What's your opinion on that suggestion?
Well, if we compare the period of training, which is now set by the law, with the period of training of professional judges in other countries like Austria, where they have a very long period of time, or in some other countries where this training is obligatory, I think that our timeline, our period of training is sufficient and it should not be reduced, because there are a lot of different specializations, jurisdictions, and they should be covered by those trainings of the future professional judge.
And, but more directly, the period of time that students spend at the National School of Judges, do you think it's appropriate? Would you increase it? Would you decrease it? Do you have any views on that?
I think that it is just sufficient, and there is one point that could probably considered in the future. This is probably a transfer of training to the period after the judge passes the selection, is already appointed for the position. Why do I say this? Because the training takes place at the state out of the state money at the state expense. And if suppose a person is not then appointed a judge, that means that the additional money from the state budget will be lost. But I mean that appointed judges should undergo trainings, or the judges who have already applied for their selection. I think that this will be possible. Now we, of course, have a lack of state money, but anyway, this will be possible. But the timeline is fine, I think.
I was particularly interested in your comment and apparent interest in dispute resolution. As I'm sure you're aware, the administrative codes of Ukraine were amended, and it provides for judge involvement in pretrial settlement conferencing or judicial assisted dispute resolution. My question really deals with whether or not there has been a training course implemented now at the National School of Justice, if you're aware of it, concerning the skills that a judge can and perhaps should have in assisting the parties in dispute resolution. And it has one additional benefit, and that is that it puts judges in touch with the people and the people in touch with their judges. So if you could comment generally, please, about the role of judges in dispute resolution as opposed to adjudication only.
Yes, court mediation, in fact, was included into the procedural codes as the result of the judicial reform. And I think that this is one of the outstanding achievements of our reform, because when people come to amicable dispute resolution while helped by a professional judge, that is going to be in favor, to the benefit of every party, and we won't have any problems with enforcement of court decisions. As far as I know, the National School of Judges has some trainings on mediation, and these trainings contain not just the theoretical grounds, but the practical block when judges have to come in touch with people and have some practical tasks where they have to polish their skills or develop their skills to further use them in case consideration in dispute resolution. I think that this is a very promising direction if it is really brought into life. And participation of the judge is very important in this process, because normally court is addressed by people who come not with the real problem they have. They are not voicing the real problem. But if the judge listens to the person, or if the mediator listens to this person, and if there is some professional mediation, I don't mean legal recommendations, I mean just a focused, guided discussion is conducted, and in that way, people may actually find out what their real problem is and set the dispute amicably. You know, when I worked as in the Council of Judges, I visited some courts and I saw how, abroad, and I was really impressed on how one of the judges was doing this dispute resolution, and I saw it with my own eyes. And the main thing is that every party that has managed to come to an agreement with the help of the judge gets the feeling that everything is fair and just. He will not need the decision, the court decision, because he has solved the problem he has come with to court.
Thank you for your answer. Thank you, Mr. Chairman.
Пані Людмила,
Людмила,
слово переходить до мене.
the floor goes to me.
Ви були суддею, а потім стали
You were a judge, and then you became an attorney at law.
В мене відбулось навпаки. Я спочатку був
It
адвокатом,
was
потім став
all
суддею.
just the opposite with me.
В в цьому сенсі трошки.
I was an attorney at law and then I became a judge.
Бачили судову систему зсередини.
This means that you saw the judiciary from the inside and now you can see it like from the outside. And I hope that you have got the full picture of what is happening to the extent it is generally possible.
Будь ласка,
Please tell me the following.
як ви вважаєте, які проблеми є в судовій системі?
What problems can you see in the judiciary?
Оцінили вже як адвокат.
And how would you assess those problems as the attorney at law? What is the main problem? Why do we have this problem with trust?
Чому судова система
Why
традиційно в кінці
is the judiciary always at the end of different rankings of different lists? Why do we have all those stereotypes about judges? Are they justified or not? What do you think? I think that you're right that this is a stereotype. And mostly these stereotypes are not justified. Just the society has been imposed with some opinions by some people. What I saw when I started working as the attorney at law, I saw some things that I've already mentioned today. I saw that there is no understanding in the community that the reputation of court is developed not by judges only, but by prosecutors and lawyers as well. And it's not only that the court itself can settle a problem, it should actually be helped by lawyers, by attorneys at law. Stereotypes are also shaped up by lawyers to justify their misdemeanor and to also somehow compensate for lack of their professionalism. There are some lawyers who claim that the judge is not a good professional instead of saying that they are bad professionals. So it also happens. What I dislike a bit is the long period you have to wait for the court sitting. I understand that this is related to high load, but we are trying to manage our time. We are paid for our time, and this is all about the interests of clients. So this calls for some inconveniences. How could we actually improve the problem with trust? I think that this must be the joint task of everyone who has something to do with the judiciary.
Зрозуміла ваша позиція, дякую.
Clear, your standpoint is clear, and you know, in your motivational letter,
Що я процитую. Моя співпраця з
you
громадськими
mentioned that my cooperation with civil society organizations and mass media points to the need for the court to be accountable to a civil society. What do you mean? I mean that civil society and all actually state authorities, all public bodies should be accountable to civil society. As far as court is concerned, this is primarily all about surveys held by civil society organizations in the court premises, because they would provide an absolutely different range of statistical data as compared to the surveys held in the streets. That is also about openness of information, not just transparency of information and highlighting of information in the register of court decisions, a provision of some general public information. This is also active getting of feedback from civil society. This is what the press secretary of the court should deal with. Well, probably not the judge speaker, but the press secretary and all the communication staff of the judiciary should be dealing with this. They should deal with the vision of the court and actually vision of the court by the judiciary. They need to give and to get feedback. So the problem is about lack of feedback. No, I don't mean that this is a problem. I just mean how this accountability could be achieved via surveys and via presentation of communication, getting feedback. Now we have only occasional cases when courts publish that the information that we have considered this high-profile case. But it would be good if there was more of this information, because this shows the high level of performance of courts, in particular now in the conditions of the war.
Також у своєму мотиваційному
Also, in your motivation letter, you indicate that,
зацитую вас.
again, let me quote you, an important characteristics of the operation of the HQCJ is maximum transparency, and the same is mentioned by a lot of candidates, and predictability of its activity. What do you mean by predictability of its operation, of its activity of the HQCJ? Well, I wrote this because I think that it still must be clear what the passing score should be. It's not just my opinion. This is what the Council of Europe wrote in its opinion about the results of the selection to the Supreme Court. And the experts of the Council of Europe mentioned that it's necessary to predetermine the passing score for the testing and the performance of the practical task. Okay, I know what you mean.
Як ви пропонуєте
Then how do you want to improve transparency of the HQCJ's operation? And was the level of transparency sufficient when we speak about the former composition of the HQCJ? I think that the former composition of the HQCJ really showed a very high level of transparency and openness. They published all the data, all the information, and within quite a short period of time, you could get access to all the selections and procedures. I think that the next composition of the HQCJ should follow in the same direction in this respect in order to provide information to the society.
з чого тоді
Okay, clear.
певне невдоволення
And where from do we get some dissatisfaction with the work of the previous composition of the HQCJ in civil society, because they have expressed such ideas?
проблемою і
What was the problem, and
новому складу
how
цю проблему не
how could actually the new composition of the HQCJ avoid this problem? I think that dissatisfaction came from the timelines. Well, they were grounded. There was really a major number of procedures, but the society always wants everything to happen overnight to see the deliverable. But unfortunately, really, this assessment was not completed. I mean, qualification assessment, and the competitions, the selections were not held for appellate courts, just launched. So a lot of things were launched and not completed because of the termination of office of members of the HQCJ, and due to the load that physically could not be handled at the same time. What does the new composition of the HQCJ do? Well, I think that probably it's worth announcing realistic, relevant timelines for all the procedures, and this could be done through planning for a year or more, to give a clear signal to the society that here is the schedule, here are the timelines we're going to follow. We will try to do our best, but here is our plan.
зрозуміло. Дякую.
Clear?
На цьому,
Thank you.
раунді
So,
питань немає.
I have not got any other questions. Robert, the floor is yours within the second round.
Yes, Ms. Volkova. I've been thinking what you have been saying, and I have some difficulty with that. You know that there is research which says that not more than 10% of the people in Ukraine have trust in the judiciary. And there's also some research that says that the one who is better off and who has more money will win in court, and that judicial bribery is not getting better, it's getting worse. And I also must say that I've been now in this commission for more than a year, and we have looked at thousands of documents and hundreds of profiles. And I'm involved in corruption cases for more than 20 years now. And I can say that from my perspective, if I look in the information I've seen, of course, there's no proof of corruption, but there is an enormous amount of red flags with different candidates. And this fact is the reason why donors of Ukraine have said something should change about judiciary. And this fact is also the reason why the European Union has said, dear Ukraine, before you can enter the European Union, you have to make sure that your judiciary is up to standard. And up to standard means that anyone who goes to court here can be sure there will be an independent judge available. But if I listen to you, and you have been a judge for quite a long time, and you have been a lawyer in a first-class law firm, in fact you say that this is not there. So if you are appointed to the HQCJ, how will this give trust to the donors and the EU that such changes that they think is necessary will be made?
Well, I didn't mean that corruption is not there. I just mentioned that I have never been a witness. I have not faced such manifestations of corruption myself. What will I do? Well, first of all, I will professionally fulfill my duties. As far as selection of staff for the judiciary is concerned, I'm still sure that the new High Qualifications Commission should go deep into the issue of professionalism and integrity of judicial candidates and be scrupulous about studying the materials of dossiers and materials of special verification procedures, and including information that you have just mentioned, the information provided by civil society in those red flags that should also be studied. I'm not sure that it's really necessary to shout from the screen or from the monitor of the computer about every red flag. First, we need to check all of them. We should not close our eyes to any facts. That's true, of course. We should not just say, okay, let's skip this. No, we need to check every single message and every single fact where there is this red flag pointing to some corruption. And these scrupulous inspections will give the signal to our European donors showing that the system is changing, and that can be traced. That is really detectable because the system is really changing. You know, many judges retired when there was an announcement made that there would be qualification assessment. So even this very announcement worked for the purification of the system. And if we have those inspections, scrupulous inspections in place, that will also affect the situation for the better.
Okay. But can the donors trust that when you are appointed in the HQCJ, you'll be scrupulous on any, let's say, signals of unethical behavior of judges? Or are you part of the system and you are not someone who will change it?
I do believe that we need to start from ourselves, and everybody can change the system as an individual. And if we dig deeper in this direction, everybody is able to change the system. I don't know how we can convince the donors about this, but I do believe that the procedure that we are currently undergoing, the selection procedure, should convince the donors that the best will be selected.
Okay. You are a founder and a member of the Association of the Development of Judicial Self-Government of Ukraine, is it not? No? Founder and member of the Association for the Development of Judicial Self-Government of Ukraine, that's what my note says. You know this organization?
Yes, I'm the founder.
You're the founder, okay.
Yes, I founded it
right.
many years ago. Yeah.
Exactly. Well, in 2021, the Association for the Development of Judicial Self-Government of Ukraine addressed the High Council of Justice to express reservations regarding the adoption of the draft law number 5068, in particular regarding the issue of the formation and activity of the Ethics Council, which, according to the association, does not correspond with the Constitution of Ukraine. In addition, the petition emphasized that international experts like us cannot have an advisory function in the formation of state bodies. Is that your view as well?
Well, in any case, I did not prepare that petition because for quite a lot of time I have not been involved in the activities of this association. I was the founder, but I'm not the active member of this association, and the law has been adopted, it has been enforced, and by observing the activities of the Ethics Council and the Selection Commission, I'm convinced that international experts do contribute with their experience, their civilizational experience, the experience of their countries. And I believe that this experience is quite necessary for Ukraine at this moment.
I must say that you're giving a perfect lawyer kind of answer. But the question was, do you believe as an individual that this system is against the Constitution of Ukraine?
Well, we have the conclusion of the Venetian Commission, and it has proven compliance with our constitution, and I have to agree with it. But if we pay attention to other countries and see other countries where international experts are involved, it's Albania, and their constitution has been amended so that international experts could be invited. I don't think whether that's necessary at this stage. Maybe it is, but the Venetian Commission has said that there is compliance with our constitution. That's why the law has been adopted, and we all have to follow it.
Okay. Thank you, Chairman. I would like to pass the floor to my dear colleague, Justice Markman. Okay.
Thank you very much, Mr. Broekhuizen. Ms. Volkova, I'd like to focus on the same provision of the motivation that my colleague Judge Mashenko focused on a few minutes ago. This has to do with the kind of reforms that you would look to if you were elevated to the High Qualifications Commission. And in particular, I'd like to focus on what I see as your priorities, the most important things that you believe have to be pursued. And I'm quoting from you. You say that the High Qualification Commission, first of all, must build an efficient team. I say that we have tried to build a team, and all the prior agencies that have been involved in judicial reform have tried to build a team. And sometimes good teams have been put together, and other times maybe the teams haven't been quite as strong. But how is it that you and the new High Qualifications Commission will ensure that there's a new team?
Well, it has to be a team of like-minded people. Secondly, we will have to get acquainted and to understand the work of the Secretariat. And for more than 40 months that the HQCJ was not operating, the Secretariat has been working. So they have this experience. And of course, it will be important to hire inspectors, those who will be ensuring training, at least supporting the development of training materials. How do we ensure that a good team is selected? Well, we will get new members of HQCJ, but with joint effort, we can create this team, the team that will include the staff, the HQCJ members, who are supposed to work with an understanding of each other. And that's extremely important, an extremely important skill. As far as the inspectors are
So you
concerned,
say that first of all, an efficient team must be put together, and then in the next sentence, or two sentences afterwards, you say the priority steps in the operation of the new High Qualifications Commission should be improving documents, efficient completion of the procedures, doing certain things 2 months in advance of the competition and doing other things 1 month in advance of the competition. If I was to respond to you and say that these seem to be matters of procedure, some are quite vague and some are more specific, but they're all questions of procedure, and that possibly more important is the substance and the quality of the people who are placed upon the High Qualifications Commission and who will be placed upon the judiciary of Ukraine. If I was to say that I think there's too much emphasis upon things of procedure that are important but less important and less focus on things of the caliber and quality and standards of the new High Qualifications Commission of Ukraine, and even more importantly, the new judiciary of Ukraine, what would you say in response to me?
as a participant of this selection, I cannot influence who the other members of HQCJ are going to be. I don't know who you are going to select. So it's for the selection commission to decide and then for the High Council of Justice. I do believe that the best will be selected because that's why the commission, the selection commission, has been set up, and this will be of importance. And with this specific team, we will have to work in the future, should we be selected. As far as the independence of the judiciary or the quality, what are the measures? Did I understand you correctly? We will first of all need to appoint judges to those courts where we are having vacancies so that these courts start working more efficiently, because I already told you about lack of judges at the appellate courts. And this results in court decisions not being enforced because we don't have enough judges. And the duration of court hearings in appellate courts is too long. That's, again, another issue of trust in the judiciary. If people get a decision that is enforced, then they are trusting the judiciary. I believe that these tough procedures are important. And their continuation is also of importance. And we are able to continue with these reforms if we have the team. But I'm not responsible for the other team members that will be selected.
Of course, you're not responsible for other team members any more than anyone on this commission is responsible for the votes of his colleagues. They may be discussed, they may be addressed within the commission, but in the end, each commissioner is independent. And you're correct. You will be part of a team. But each team is only as good as its individual members. You will be one of the individual members, one of the small number of individual members of that team. And I guess what I'm trying to ask you is, what will be your individual sense of priorities and your individual passions? What is most important to elevating the Ukrainian judiciary to the highest international standards possible? I'm hearing much about the team, but what will Judge Volkova do to make sure that the team is as strong as it possibly can be?
Well, first of all, the team is important. I will have to reiterate that. But me personally, I will put all my effort, I will put all my time to initiate the necessary procedures so that we continue the procedures already started. So regardless of the heavy workload, I will do everything for all those procedures to be completed. We will have to check the test. We will have to study the dossiers. We will need to get as much information about the candidates as possible. That's extremely important because, as I've already mentioned, examination of every fact, of every detail may have a decisive meaning for the candidate. There are some questions who, for an outside observer, may cause concerns or may be a reason for dissatisfaction. So I believe that I personally need to do everything that the information about every candidate is studied in detail.
Thank you, Judge. Appreciate it.
Mrs. Volkova, I'm interested in a statement that you made in answer to question 9 that we have put to all candidates. You made the following statement. My experience as a teacher at the National School of Judges allows me to evaluate which knowledge and skills are essential for a modern professional judge. I wonder if you would share with us your view of what knowledge and skills are essential for a modern professional judge.
Taking into account the fact that Ukraine is trying to become a member of the European Union, I do believe that it's important for us to understand what the approaches of the European Court for Human Rights is. There has been some time when the state judicial administration was running a survey about the number of references to the decisions of the European Court of Human Rights made by Ukrainian judges. I don't think this is a very useful practice. We need to form these approaches in the interpretation of Ukrainian legislation based on the practice of the European Court for Human Rights. Also, we need to develop the skills for interpretation of law as based on the decisions of the Court of Justice. Well, this is not the source of law in Ukraine, but the approaches and the understanding should be formed today. And the association agreement even has reference to intellectual property decisions of the Court of Justice, as far as I remember. So this kind of understanding and this kind of interpretation of legislation is something that judges need. Because of the amendments to the Constitution, the judges are supposed to interpret legislation. And in any case, communication skills are also very important, because if previously the judiciary was one of the most closed systems in Ukraine, today it's trying to become the most open, the most transparent. And to achieve this communication balance, we need to form these skills in judges.
Thank you. Thank you, Mr. Chairman.
Будь ласка.
Пані Людмила, в продовження запитання.
So, Liudmyla, as a follow-up question to the question of Ted Zajechny, and in view of your activities as a trainer at the National School of Judges, do you believe that we need to change the approaches towards the professional training of judges? Do you mean the training for enhancement of qualifications, or do you mean the training for candidate judges? Both. Well, I believe it was really good that we have trainings, because training is the best way to teach adults, and I'm indeed grateful that I was part of the Canadian program that taught us how to teach adults. And as far as the format of trainings is concerned, it's very beneficial. If we consider the war in Ukraine, offline studies are currently impossible. That's why remote studies are also efficient. Why? Because a judge is not interrupted in their work process. They can enhance their qualification in their spare time, and they have more time to process different materials. That's why I believe that remote studies are also very efficient. And I hope that in the near future, when the war is over, and the judges will get together for trainings, for enhancement of their qualifications offline, it will also become very efficient because it will give them a chance to exchange their opinions, to communicate, because informal communication is indeed important for us to create different practices, because we discover the practices of other courts and other judges. As far as training is concerned, I mentioned training sessions of importance, and also practical assignments, visiting the courts, being present during a court hearing that also teaches future judges about the procedure, because when you start out and you don't know what you are supposed to do, it's very complicated, and the people have already shown up for a court hearing and they're expecting a judge of the highest level. In view of your experience, how much time is necessary to train a candidate judge, somebody who will be appointed a judge for the first time? Well, we should be starting with the fact that this is a professional lawyer already, who has some professional experience, who is already of a certain age. But the time indicated in the law, 12 months, I believe this is sufficient enough. And how often should we have requalification of incumbent judges? So currently, we have the interval of 3 years. But if we have a look at the different trainings, different discussions offered by the National School of Judges, I think that the judges attend different other events in between. So they attend remote courses, and when we're back to our peaceful life, they will attend even more events. And the National School of Judges has changed for the better. It has become relevant. So in your opinion, it has changed for the better, yes? Yes. Yes, indeed, because the things that are relevant for today are being introduced by the National School of Judges. We can see that the category of cases may be problematic, and then at the National School of Judges we decide to organize a training dedicated to this category of cases so that we can invite some judges and discuss these things. The approaches in the society change faster than the legislation does, and the judge is working under existing circumstances, and a judge themselves creates the practices and approaches. Thank you.
Do you have any further questions? No, thank you. Colleagues, no? Пані Людмила, інтерв'ю підходить співбесіді.
Liudmyla, your interview is coming to an end.
Що б ви такого хотіли сказати на останок?
Is there anything that you would like to tell us towards the end? Anything that you'd like to draw our attention to as a concluding remark? Is there anything of importance that you'd like to add? Well, to conclude, I would like to mention the key tasks for the new HQCJ. So we have to implement the principle of zero tolerance. We need to adjust our legislative basis to work under conditions of law. And if we talk about other priorities, it's completion of qualification assessment and its initiation of new qualification assessment for those judges who have not yet completed the procedures. And if we talk about strategic tasks, these are the measures that will help us to hire new people in a sustainable way as we are moving towards becoming part of the EU.
Дякую вам.
Thank you.
На цьому інтерв'ю завершено.
So this is the end of your interview. Goodbye. Good luck to you. Goodbye.